Picture this: a courtroom. It's a place built on words, the sworn testimony of witnesses, the precise arguments of lawyers. Everything feels like it rides on what is spoken, what is heard. But sometimes the real story, the source of potential injustice even, lies in what isn't said, the questions deliberately left unasked.
Exactly. And that's the breeding ground for something lawyers call trial by ambush. It's the idea that you let a witness give their account, perhaps under cross-examination even, and then later, much later, maybe in your closing speech to the jury.
Or by calling another witness.
Right, or by calling someone else, you suddenly spring an attack on that first witness's truthfulness or accuracy regarding something you never gave them the chance to explain or defend themselves on while they were on the stand.
Yeah.
It feels instinctively unfair, doesn't it?
It absolutely does. And our legal system has a foundational principle specifically designed to prevent that kind of surprise attack. It's known as the rule in Browne v. Dunn.
Ah, yes, the famous one.
At its heart, it seems simple enough. If you intend to challenge a witness's account, to suggest they're lying or mistaken, or that your version of events is different from theirs, well, you must put that challenge to them when you're cross-examining them.
You got to give them the opportunity to respond.
Exactly. Give them that chance.
It's about fair play,
Yeah.
really. Giving that witness their moment in the box to address the specific imputation you plan to make against their credibility. Without that chance, the later attack feels like, well, hitting someone when their back is turned.
And today, for this deep dive, we're going to trace the remarkable journey of this seemingly simple rule. We're going to go back to its very origins, born out of a peculiar, almost theatrical dispute in Victorian England.
It was quite something.
And follow its path across over a century and halfway around the world to Australia. There, this old common law principle faced a completely different, deeply sensitive challenge in a high-stakes criminal case before the High Court. MWJ VR. It's a case that didn't just apply the rule, but profoundly reshaped how it applies in the unique context of defending someone accused of a crime.
It's a perfect illustration of how these foundational legal principles aren't static. They're living things,
Yeah,
constantly tested, interpreted, and refined by the courts to meet the demands of modern justice.
absolutely. So our mission in this deep dive is to unpack the dramatic story behind Browne v. Dunn and MWJ VR. We'll meet the key figures whose lives became entangled in these legal dramas.
The dramatis personae, as it were.
Indeed. We'll trace the procedural steps as these cases wound their way through the court system and explore the really significant, lasting impact the High Court's decision has had on the day-to-day practice of law and fairness in Australian courtrooms.
And it's quite a significant impact.
So why should you care? Because this story gets right to the heart of how our justice system balances the need to rigorously test evidence with the fundamental right of an accused person to a fair trial, particularly when facing challenging allegations from the distant past. It touches on the integrity of the courtroom process itself.
It really does. It's fundamental stuff.
Okay, let's unpack this. Right, so to truly appreciate the weight and significance of MWJVR, we have to set the scene for where the principle it clarified first emerged. That takes us back over 130 years, across the seas to England, to a place called the Vale of Health in Hampstead, London.
Lovely sounding place.
In the late 19th century. Now, despite the tranquil-sounding name, this wasn't a place of perfect harmony. The rule in Browne v. Dunn didn't arise from a grand constitutional battle or a sensational murder trial.
No, not at all.
But from a rather heated dispute between neighbors, specifically a libel action. It was a fight over reputation.
That's what makes this origin story so compelling, I think. It's a high principle born from what might seem like a relatively low-stakes squabble, at least compared to the serious criminal cases it influences today.
Absolutely. So our primary dramatis personae in this original case are Mr. James Loxham Browne, the plaintiff. He's described as a solicitor neighbor who felt his good name had been, as the sources put it, unjustly besmirched.
Besmirched. Good word.
And the defendant was Mr. Cecil W. Dunn, another solicitor.
A solicitor versus solicitor dispute, often quite bitter.
Seems so. And the conflict centered on a document that Dunn had prepared. But it wasn't just the two solicitors involved. This document was circulated among other residents of the Vale of Health.
Right, they brought others into it.
People like Mr. Samuel Hawke, Mr. S. Jones, Mr. E. Cook, and significantly Mr. George McCombie, among others. These signatories are crucial to the story because their later testimony became the focal point of the legal principle.
Okay, so what was in this document?
Well, the document itself was essentially a formal request to the local magistrates. It sought authority from the residents for Dunn to apply for an order binding Mr. Browne over to keep the peace.
Like a restraining order almost, or a peace bond.
Something like that, yes. The grounds for this application were set out in the document itself, alleging that Mr. Browne had continuously for many months past, both by acts and words, seriously annoyed us, and each of us, whereby he has endeavored to provoke a breach or breaches of the public peace.
So the residents were claiming Browne was harassing them, annoying them to the point of potentially causing trouble.
That was the claim, and they hired Dunn, the solicitor, to act on their behalf to seek this legal remedy. But Mr. Browne saw it very differently. His claim in the libel action was that this whole exercise, the document, the alleged annoyance, even the residents supposedly hiring Dunn, was nothing more than a sham.
The plot thickens.
He asserted it was a malicious contrivance designed purely for annoyance and injury to Mr. Browne. In his view, the residents weren't genuinely annoyed. It was all a calculated, malicious attack orchestrated against him, perhaps even with Dunn's help.
Right, so he's saying Dunn wasn't acting properly for genuine clients, but was part of a conspiracy to defame him.
Precisely. And so the trial of this libel action began before Mr. Justice Matthew. The key evidence for Mr. Dunn, the defendant, was the testimony of these residents who had signed the document. People like Mr. McCombie and Mr. Hooch were called as witnesses for the defense.
Okay, so they get into the witness box.
And they testified that they were genuinely annoyed by Browne and that they had genuinely authorized Dunn to act for them, right? This directly countered Browne's sham argument.
Precisely. Their testimony was vital to Dunn's defense. If they were genuinely annoyed and had genuinely instructed Dunn, then Dunn preparing the document was a legitimate act on behalf of clients, not a malicious contrivance. Makes sense.
And this is where the now famous omission occurred. The failure to cross-examine that became the source of the rule. Browne's counsel, his legal team.
The plaintiff's team.
Yes, Browne's lawyers largely failed to challenge this crucial aspect of their testimony in cross-examination.
That's quite extraordinary given Browne's whole case rested on it being a sham.
It seems so. The sources highlight this vividly. Lord Herschel, in the House of Lords later, would quote what was said to some of these key witnesses. "I have no questions to ask."
Wow. Just nothing on the core issue.
Apparently so, for some. For others, the cross-examination on the core issue, whether their annoyance was genuine and whether they truly authorized Dunn, was largely skirted.
Skirted. So they didn't directly put the challenge.
It seems not directly or not effectively. The witnesses get in the box, swear under oath that they were annoyed and hired Dunn, and Browne's lawyer just didn't challenge them squarely on it. Didn't say, "Mr. McCombie, I put it to you that your annoyance was not genuine," or "Mrs. Cook, I suggest you never truly retained Mr. Dunn, that this was all part of a plan."
That's exactly what happened, or rather didn't happen, on this critical point, according to the law lords later. The defense case rested heavily on the genuineness of the residents' annoyance and instructions, and Browne's counsel left that evidence standing unchallenged in cross-examination.
But here's the twist at trial.
What happened?
Despite this lack of challenge, and perhaps counterintuitively given the unchallenged testimony, the jury found for Mr. Browne. They agreed he had been libeled by the document.
Really? Even though his lawyer didn't challenge the key witnesses on the sham point. That is surprising.
Maybe they were persuaded by something else, or just didn't like Mr. Dunn or the neighbors, who knows. But the case didn't end there, of course. Mr. Dunn appealed.
As you'd expect.
The Court of Appeal overturned the jury's verdict, finding for Dunn, and then Mr. Browne appealed that decision to the ultimate Court of Appeal for English cases at the time, the House of Lords.
Right, up to the top court.
And it was in the House of Lords that the conduct of Browne's counsel regarding that cross-examination was put under the microscope, leading to the definitive articulation of the rule.
Okay, this is the moment. Who heard the case there?
The law lords who heard the appeal included Lord Herschel LC, Lord Chancellor, Lord Halsbury, Lord Morris, and Lord Bowen. A heavyweight panel.
Definitely. And what did they say about this failure to challenge the witnesses?
Lord Herschel, leading the judgment, was unequivocal. He stated it was absolutely essential to the proper conduct of a cause for counsel if they intend to suggest a witness is lying or mistaken.
Which Browne's counsel clearly intended, given the nature of the claim.
Exactly. Counsel must direct his attention to the fact, showing that that imputation is intended to be made. He explained the fundamental reason. It is essential to fair play and fair dealing with witnesses, giving them an opportunity of making any explanation which is open to him.
Makes perfect sense. If you don't give them that chance during cross-examination, it's unfair to ask the judge or jury to disbelieve them later based on something they never heard or got to respond to.
And Lord Halsbury was even more forceful, wasn't he?
Oh, yes. He didn't mince words at all. He called the failure to cross-examine those witnesses on their core evidence and then turn around to the jury and ask them to disbelieve that evidence. He called it an outrageous thing.
Strong language from a law lord.
Very. He described it as a perfect outrage and violation of the proper conduct of a case. He also made a related point about the nature of litigation itself. You must squarely put your case and challenge the evidence against you at the trial stage.
You can't hold back your ammunition.
Pretty much. You can't deliberately fight on one point and then if you lose, try to win on appeal by raising entirely new arguments or challenges that weren't properly put to the witnesses at the time. It's about procedural fairness to the other side and the court.
So it was about fairness to the witness and fairness to the court process itself. Was this a completely unanimous view among the law lords?
While agreeing with the core principle, Lord Morris added a small but important nuance, a qualification.
What was that?
He cautioned against making this a hard and fast rule with absolutely no exceptions. He acknowledged that in rare cases, a witness's story might be so obviously incredible and romancing that perhaps the most effective cross-examination is simply to let them finish and then argue its absurdity later.
Let them hang themselves with their own rope, so to speak.
Kind of, but he made it clear this would be a very unusual circumstance, and the general rule applies. You generally must put the challenge.
And the outcome for Mr. Browne in the House of Lords?
His appeal was dismissed. The House of Lords upheld the Court of Appeal's decision, siding with Mr. Dunn. The rule in Browne v. Dunn was firmly established in common law.
Born from this neighborhood squabble.
Exactly. A direct consequence of the perceived unfairness in how the defense witness's testimony was handled, or rather not handled, by Browne's counsel at the trial. It became a cornerstone principle of fair cross-examination.
It's incredible to think that this fundamental rule, taught in law schools and applied daily in courtrooms everywhere the common law holds sway, has its roots in a Victorian-era dispute over whether a solicitor was genuinely annoying his neighbors or whether the complaint against him was a malicious fabrication.
It really highlights how the law develops organically, doesn't it? Responding to the specific injustices or procedural failures that arise in real cases, no matter how seemingly minor their beginnings might appear compared to later applications.
Okay. And that brings us to the second act of our story, one that takes this venerable 19th century principle and transplants it into a very different and deeply challenging 21st century context.
A big leap in time and place.
We leap forward over 100 years and across the planet to Australia, specifically to the regional industrial city of Whyalla in South Australia. Here, the principles of fairness from Browne v. Dunn were tested in a case involving serious historical criminal allegations.
This modern case is known as MWJ-VR. It uses anonymized initials, MWJ, because of the highly sensitive nature of the charge's allegations of child sexual assault.
Extremely sensitive. Who are the key figures here, the modern dramatis personae?
Well, there's MWJ, the man accused, who became the appellant in the High Court. Then there was M, the complainant. She was 25 years old when the trial took place.
Okay.
She was alleging offenses that had occurred more than a decade earlier, during her childhood, specifically when she was between the ages of approximately 8 and 13.
Wow, a very long time ago.
A huge gap. And also central to the evidence was M's mother, referred to as D. She had lived with MWJ and M during the periods when the alleged offenses took place.
Right, so we have the accused, the complainant, and the complainant's mother all living together at the relevant times.
Yes.
So these are extremely serious charges, and the fact that they are historical, spanning potentially over a decade, maybe even more, from incident to trial, that presents significant challenges for everyone involved, doesn't it?
Oh, absolutely. The time gap is immense and creates inherent difficulties. Memories, as we know, can fade, they can distort, or they can be influenced over many years. Physical evidence is almost certainly gone by that point.
And the emotional toll must be huge.
Profound, yes. For complainants in historical abuse cases, recounting these events is incredibly difficult. And for the accused, defending against allegations from so long ago, when alibis are often impossible to verify and potential witnesses may have moved on or passed away, is incredibly challenging too. These cases really test the justice system in unique ways.
And the fact that the allegations arise within a cohabitation relationship involving M, her mother D, and MWJ living together, that adds another layer of complexity, surely.
It certainly does. The dynamics of that household could play into how people remember things, how they testified, and where perceived inconsistencies might arise between their accounts. Family dynamics always add complexity.
So where did the trial take place?
The trial of MWJ took place in the Supreme Court of South Australia. He pleaded not guilty to the charges. And importantly, this was a judge-alone trial.
No jury.
No jury. The judge was responsible for deciding both the facts, whether the events happened as alleged, and the law.
What formed the prosecution's case against MWJ? What evidence did they present?
The core evidence came from the testimony of M, the complainant, and her mother, D. Their accounts of what happened were absolutely central to the Crown's case.
Okay. And how did the defense approach challenging this evidence? What was their strategy?
The defense strategy aimed to cast doubt on M's reliability as a witness. A key way they attempted this was by highlighting alleged inconsistencies between M's testimony and D's testimony.
Differences between the mother and daughter stories.
Exactly. The sources specifically mentioned discrepancies relating to whether the alleged misconduct at one of the residential locations, Sutcliffe Street, was a single incident or part of a course of conduct over time.
Okay, a potentially significant difference.
Well, the defense's argument was that these inconsistencies undermined M's overall credibility and meant her evidence should not be accepted beyond a reasonable doubt. If the mother and daughter couldn't agree on basic details, how could the judge be sure the core allegation was true? That was the thrust.
So the defense sees differences between the daughter's story and the mother's story about a specific event or period, and they want the judge to consider those differences as grounds to doubt the daughter's account. How did the trial judge respond to this tactic, particularly in light of Browne v. Dunn?
This is where it gets really interesting legally. The trial judge made observations that directly referenced the rule from Browne v. Dunn. The judge commented that it would have been unfair for the defense to rely on D's evidence as effectively being prior inconsistent statements to challenge M's credibility,
Right.
unless those alleged inconsistencies had been put to M during her cross-examination, allowing her a chance to respond.
So, applying the classic Browne v. Dunn principle.
Seemingly so. The judge went further, stating that had there been an inconsistency that the defense wished to rely on, defense counsel would have been obligated to have put this to M.
Obligated. That's quite a strong word in this context. So the judge was essentially saying, defense, if you think D's evidence contradicts M's in a way that harms M's credibility, you needed to confront M with that specific contradiction when she was on the stand, according to Browne v. Dunn. You had a duty to do it.
That was the judge's initial perspective on the defense strategy regarding these inconsistencies. However, and this is a crucial twist in the trial judge's reasoning, the judge then concluded that, in truth, there was no inconsistency between M's and D's evidence on that particular point anyway.
Oh, so after saying the defense should have put it, the judge then finds there was nothing to put.
Exactly. Therefore, the judge decided the question of whether Browne v. Dunn had been breached and any consequences flowing from such a breach didn't need further consideration. It was moot.
So the judge identified a potential Browne v. Dunn issue with the defense's approach, criticized them for not putting the supposed inconsistency, suggested they were obligated to, but then ultimately ruled that it didn't matter because the factual premise for the issue, the inconsistency itself, wasn't actually present in the evidence.
That's right. It's a bit of a convoluted path. The judge seemed to think the rule applied rigorously to the defense's use of potential inconsistencies, but then ultimately decided the point was irrelevant on the facts as found.
Okay. What was the verdict for MWJ at the end of the trial?
The outcome was a split verdict. MWJ was acquitted on the charge relating to the earlier period, the allegations from 1986-1987.
Right.
But he was convicted on the 3 charges relating to the later period, the allegations from 1990-1991.
A split verdict in a historical case like this often suggests the judge carefully considered the evidence relating to each alleged incident or period separately, doesn't it? Weighing the strengths and weaknesses for each count.
It certainly points to a granular assessment of the evidence, rather than a blanket finding of guilt or innocence. The judge was evidently persuaded beyond reasonable doubt regarding the later allegations, but not the earlier one. Perhaps the evidence was stronger, or memory clearer for the later period.
Possibly. And the lawyers involved at this Supreme Court trial stage, did the sources mention who they were?
Based on the sources provided for this deep dive, the specific names of the solicitors and barristers who represented MWJ or the Crown at the Supreme Court trial in South Australia are not available. We don't have those names.
Okay. So, after the trial, MWJ has convictions for 3 serious charges, acquittal on 1, and there's this lingering question about the trial judge's comments on the defense's conduct and the application of Browne v. Dunn regarding the alleged inconsistencies. This procedural point, tied to the core issue of fairness, it feels like it was destined for appeal.
Absolutely. The legal battle moved up the system, first to the South Australian Court of Criminal Appeal, known as the SASC-CCA. Here, the case was referred to as RV-MWJ. MWJ appealed his convictions, naturally, and his legal team raised several grounds, primarily challenging the trial judge's handling of the evidence, and critically, the judge's observations about the defense's use of the alleged inconsistencies and the application, or misapplication perhaps, of Browne v. Dunn.
So the appeal was squarely aimed at that point, where the trial judges suggested the defense was somehow obligated to put the inconsistencies to M.
Yes, that was a key focus. MWJ's lawyers argued that the trial judge had misunderstood and misapplied the Browne v. Dunn rule, at least in the way they suggested. It constrained the defense's ability to rely on inconsistencies between witnesses.
Who was on the bench for the FASC-CCA appeal? Which judges heard it?
The appeal was heard by Chief Justice Doyle, Justice Bisanko, and Justice White.
And what was their decision regarding this Browne v. Dunn point? Did they agree with the trial judge?
The FASC-CCA reviewed the trial judge's comments, and they actually agreed with the appellant, MWJ, on this point. They found that the trial judge had erred in suggesting that the defense was precluded from relying on the inconsistencies between M's and D's evidence simply because they hadn't been put to M during cross-examination.
Okay.
They held that defense counsel was entitled to rely on those inconsistencies as potentially affecting M's credibility, regardless of whether M had been cross-examined on them.
So they corrected the trial judge's specific statement on that point. A win for MWJ on the legal principle, then.
On the principle, yes. But did they feel the omission to cross-examine was completely consequence-free?
Good question. What did they say?
No, they didn't go that far. While saying the defense could rely on the inconsistencies, the SASC-CCA determined that the lack of cross-examination on those points was still relevant. They held that the omission was relevant to the weight the court should give to that inconsistency evidence.
Ah, okay. So not inadmissible, but less persuasive.
Exactly. In their view, not putting the point to the witness weakened the force of the inconsistency when the judge came to weigh everything up. They also suggested a potential remedy.
What was that?
They suggested that defense counsel could have addressed any potential unfairness by asking M to be recalled for further cross-examination to specifically confront her with D's potentially inconsistent evidence.
So for the CCA, failing to put the point didn't ban the evidence, but it made it less persuasive and perhaps required a procedural fix, like recalling the witness. That seems like a more pragmatic approach.
That was their approach, yes. They saw it as affecting the weight of the evidence and suggested a remedy to cure any prejudice to the prosecution or the court from the omission.
What was the final outcome of the appeal before the CCA? Did MWJ get his convictions overturned?
No. Despite finding that the trial judge had erred in principle regarding Browne v. Dunn, the SASC-CCA ultimately dismissed MWJ's appeal. They concluded that, taken as a whole, there was no miscarriage of justice.
No miscarriage of justice, that key phrase again. It means that while an error of law occurred, the appeal court didn't think it was significant enough to have actually made the trial unfair or the verdict unsafe.
Precisely. The SASC-CCA was satisfied that, notwithstanding the identified error in the judge's comments on Browne v. Dunn, the overall outcome of the trial was still sound, and the convictions were safe based on the evidence the trial judge accepted. So the convictions have stood.
And the legal teams for the SACCA appeal, any names there?
Similar to the trial stage, the provided sources do not name the specific solicitors or barristers who represented MWJ or the Crown before the South Australian Court of Criminal Appeal. That information isn't available to us.
Okay, so the SACCA corrected the trial judge on the Browne v. Dunn application but found it didn't change the outcome. This disagreement on a fundamental principle of trial fairness, especially how it applies to the defense, meant the case had further to go.
It really did. It went all the way to the highest court in the land, the High Court of Australia. This is where the definitive national position on how Browne v. Dunn applies, particularly to the defense in criminal trials, would be settled.
A case of national importance.
Reaching the High Court signals that, yes, the case raised an important question of law that needed clarification for the entire country. The case there was titled MWJ v. the Queen.
Who was on the High Court bench for this landmark decision?
The case was heard by Chief Justice Gleeson and Justice Gummo, Kirby, Callanan, and Hayden, a very experienced and formidable panel.
Indeed. What were MWJ's arguments before the High Court? What were they asking for?
MWJ's appeal argued essentially two main things. First, that the SSC-CCA had also misapplied Browne v. Dunn by saying the failure to cross-examine affected the weight and suggesting recall was needed. And second, more broadly, that the alleged inconsistencies in the evidence were significant enough that, if properly considered without the Browne v. Dunn confusion, they should have led to his acquittal on all charges.
So, attack the legal reasoning of the ASC-CCA and re-emphasize the factual inconsistencies.
Pretty much.
And what was the High Court's judgment? Did they agree with the ASC-CCA, the trial judge, or take a completely new approach?
They delivered a unanimous judgment dismissing MWJ's appeal, so the convictions were ultimately upheld.
So MWJ still lost in the end.
He did. However, the real significance of their judgment wasn't the outcome for MWJ himself, but the profound clarification it provided on the application of Browne v. Dunn in criminal trials across Australia. This is the key takeaway.
Okay, this is where it gets really interesting for legal practice. What was that crucial clarification?
First, the High Court confirmed unequivocally that the rule in Browne v. Dunn does apply in Australian criminal proceedings. Gleeson C.J. and Hayden J. noted it's a requirement is accepted and applied day by day in criminal trials. So no question of the rule's existence or general relevance in criminal courts.
Okay, baseline established. But then came the important qualifications, I assume.
Exactly. And these qualifications are particularly significant when considering the conduct of the defense. The High Court stressed that Browne v. Dunn must be applied cautiously in criminal trials and viewed carefully in light of the nature and course of the proceedings.
Why is that caution necessary, especially for the defense? What's different about the defense position?
This is the heart of the High Court's message. They made it crystal clear that the application of Browne v. Dunn must not displace the prosecution's fundamental burden of proof.
The burden of proof. Always key in criminal law.
Absolutely paramount. In a criminal trial, the prosecution must prove guilt beyond a reasonable doubt. The defense is not required to prove innocence. The defense isn't there to help the Crown make its case stronger or, iron out its evidential wrinkles or inconsistencies.
So the rule shouldn't force the defense to inadvertently help the prosecution.
That's the core idea. And what did the High Court say specifically about the point that had troubled the lower courts? The defense's failure to cross-examine M on the alleged inconsistencies with her mother D's evidence.
Yes, that specific point about the supposed obligation.
This was perhaps the most direct contradiction of the lower courts. The High Court held there was no obligation on defense counsel to question M about those inconsistencies, nor was there any obligation to recall her for that purpose.
No obligation at all.
None. They stated this was a forensic matter for defense counsel to decide. It was a tactical decision about how to conduct the case in the best interests of their client.
So the trial judge suggesting an obligation and the SECCA saying failure affected weight and recall was needed, they were actually wrong on that specific point, according to the High Court.
Yes. The High Court explicitly described the lower court's view on that specific obligation as a misapprehension of Browne v. Dunn's application to the defense. Defense counsel is not obliged to put every potential inconsistency between Crown witnesses to every witness.
Especially if it's not a direct attack on that witness's honesty.
Right, particularly if it's just highlighting a difference between accounts. They can choose to highlight those inconsistencies differently, perhaps by relying on them in closing arguments or through another witness's evidence without having to put it to the first witness. It's a tactical choice.
That feels like a really fundamental statement about the role and freedom of the defense. Why then was MWJ's appeal ultimately dismissed, even though the High Court found the lower courts had misapplied Browne v. Dunn in this crucial way?
That's the critical distinction between the law and the facts here. While they corrected the legal principle regarding the defense's obligations under Browne v. Dunn, the High Court ultimately agreed with the trial judge's factual finding.
Which was?
That despite the defense trying to highlight them, the alleged inconsistencies between M&D's evidence on that specific point were not significant enough to undermine the convictions.
So the factual weakness wasn't there even if the defense tactic was permissible?
Correct. The evidence, as accepted by the trial judge, still supported the judge's finding of guilt beyond reasonable doubt on the 3 charges MWJ was convicted of, notwithstanding the debate about the procedural rule. The inconsistency just wasn't fatal to the Crown case on those counts.
So the debate about Browne v. Dunn was resolved in MWJ's favor in the High Court in terms of legal principle for the defense, but the factual finding about the insignificance of the inconsistency meant it didn't change the outcome of his specific case. Did the High Court provide any broader guidance beyond that specific point for future cases?
Yes, very helpfully. Justices Gummo, Kirby, and Callanan in their joint judgment offered some very useful practical guidelines for trial judges and practitioners moving forward. Things like, judges should generally avoid making adverse findings against a party based solely on noncompliance with Browne v. Dunn, noting that cross-examining any relevant witness on a point can sometimes serve as sufficient notice to the other side, stating that offering to recall a witness whose evidence wasn't challenged can often remedy any potential prejudice if prejudice exists, and suggesting that temporarily excusing witnesses rather than discharging them entirely is a good practice to facilitate recall if genuinely unexpected issues arise later in the trial.
So, practical tips for managing the trial fairly.
Exactly. And the core message from the High Court regarding the defense was clear. They don't have to help the prosecution's case. Their decision whether or not to cross-examine a witness on a particular point, unless it's a direct imputation against character or honesty,
It must be put.
which generally must be put, yes. But otherwise, the decision is a tactical one, and Browne v. Dunn shouldn't be used to force their hand or imply they have to assist the Crown in shoring up its evidence.
It protects the defense's tactical freedom, holds the accused's right to silence in a way.
Yes, because they can't be forced to give evidence just to address a point their lawyer didn't put.
And, most importantly, reinforcing that the burden of proof rests squarely and entirely with the prosecution.
Precisely. This judgment was crucial in setting those boundaries.
And who are the lawyers representing the parties in this pivotal high court case? The ones arguing these fine points.
As with the lower courts, the sources provided for this deep dive do not name the specific solicitors and barristers who represented MWJ or the Queen at the High Court stage. We don't have that information.
Okay, so MWJ v. R didn't just confirm Browne v. Dunn applies in criminal law. It drew a very important line, particularly for the defense, clarifying that the rule must bend to protect fundamental principles, like the burden of proof and the accused's right not to self-incriminate or assist the Crown. This must have had a significant ripple effect on how trials are actually conducted in Australia.
It absolutely did. It led to direct changes, or at least clarifications, in how trial judges instruct juries and how lawyers, particularly defense counsel, approach cross-examination strategy.
What was the main change for judges when addressing a jury about a Browne v. Dunn type omission by the defense?
Post-MWJ-VR, trial judges have to be much more cautious and precise if they comment at all on a defense lawyer's failure to cross-examine a witness on a particular point. The standard direction given to juries when this situation arises was refined.
How so?
It typically involves the judge simply noting that the matter wasn't put to the witness therefore didn't have the opportunity to respond, and as a result, the jury hasn't had the benefit of hearing the witness's potential explanation or evidence on that specific point, just stating the factual consequence.
But not suggesting fault or drawing adverse inferences.
Generally not drawing adverse inferences against the accused. What about the old idea that if a point wasn't put to a witness, you could infer that the defense's later argument or the accused alibi on that point must be a recent invention, made up later? The recent invention inference. MWJ, VRR, and subsequent cases like Foley v. the Vitti, the Queen significantly restricted the use of that inference based purely on a Browne v. Dunn omission by counsel.
So you can't easily jump to that conclusion anymore.
No. Suggesting a story is a recent invention based on counsel's omission in cross-examination is now only permissible in exceptional cases, and if such a direction is given, it must be worded with extreme care.
What kind of care?
The sources emphasize the need for the judge to explain to the jury the complexities of trial preparation, the role of counsel, the pressures of litigation, and that the omission might simply have been an oversight, a mistake, or a deliberate tactical decision by the lawyer.
Rather than evidence that the accused's story is false or made up on the spot.
Exactly. The jury is guided not to jump to conclusions that unfairly penalize the accused for their lawyer's conduct or choices. The direction must make it clear that the jury should not draw such an adverse inference unless they are satisfied there is no other reasonable explanation for the omission.
That's a high bar. It safeguards the accused from being prejudiced by something potentially unrelated to their own truthfulness.
It does. And this was further clarified, didn't it? Even protecting the accused from feeling pressured to explain their lawyer's actions.
Yes, in the later High Court case, Hoffer v. the Queen, the court added another layer of protection. They explained that a defendant shouldn't feel compelled to explain why their lawyer didn't ask a particular question in cross-examination.
Because that might involve revealing confidential instructions.
Exactly. Potentially having to reveal their instructions to their lawyer. The accused doesn't have an onus to account for their lawyer's tactical choices or possible errors. This means that when cross-examining an accused person about their defense lawyer's omissions, assumptions about the client's instructions shouldn't be made if other plausible reasons for the omission exist, like tactics or mistake.
So the principle solidified by MWJ has led to concrete changes in how courtrooms operate, aiming to prevent Browne v. Dunn from being weaponized against the defense. Have we seen this play out in specific cases since MWJ?
Yes, a clear example is the Queensland Court of Appeal case, RVMAP. This involved charges of rape, and an issue on appeal was the trial judge's comments regarding the defense lawyer's failure to put a specific denial, the denial of digital penetration, to the complainant, who was referred to as Ms. S.
Okay, another sensitive case. Who heard the RVMAP appeal in Queensland?
That case was heard by President McMurdo, Justice Keene, later of the High Court himself, and Justice Jones.
And applying the principles from MWJ what did the Queensland Court of Appeal find?
Justice Keene, whose reasoning on this point is highlighted in the sources, applied MWJ and emphasized the required caution. He noted that strict application of Browne v. Dunn regarding defense omissions is especially inappropriate when the point that wasn't put is otherwise apparent or clearly in issue in the case anyway.
What did that mean in RVMAP?
Well, in RVMAP, for example, the Crown had actually tendered into evidence a record of interview where the appellant explicitly denied the digital penetration.
So everyone involved in the case, the judge, the prosecution, the defense, already knew the denial was the defense position because it was in evidence tendered by the Crown.
Precisely. Justice Keene observed that none of the lawyers involved could have held any real doubt regarding the appellant's denial of this fact. Given this, the Court of Appeal criticized the trial judge.
For what specifically?
For not adequately warning the jury that defense counsel's failure to cross-examine Ms. on this specific denial might simply have been an oversight or tactical choice, and for not cautioning the jury against drawing negative inferences against the accused based on a potential error or strategic choice by their lawyer, especially when the denial was already known.
So RVMAP serves as a practical demonstration of how MWJ's principles are used by appellate courts to ensure that an accused person isn't unfairly penalized for a strategic choice or, frankly, even a mistake by their legal representative.
Exactly. What about the impact on lawyers themselves day to day, beyond judges' directions? How did it change things for defense and prosecution?
For defense counsel, MWJ provided a much clearer understanding of the boundaries. They know they are not required to put every single inconsistency or detail gleaned from other evidence to Crown witnesses, especially if doing so isn't tactically advantageous or necessary for the defense case as a whole.
So, more confidence in tactical decisions not to cross-examine on certain points.
Yes, it affirms that the decision on what to cross-examine on is largely a tactical one, providing it doesn't involve a direct attack on a witness's character or truthfulness without giving them a chance to respond. That fundamental fairness still applies.
And for the prosecution, what did MWJ remind them of?
It serves as a crucial reminder that Browne v. Dunn applies fully and forcefully to them. If an accused person chooses to give evidence, the prosecution must put any version of events they intend to challenge, including prior inconsistent statements, squarely to the accused during cross-examination. They can't hold back and ambush the accused later either.
That's reinforced in other cases too.
Yes. Cases like R.V. Lewington reinforce this. More broadly, it highlights the high standard of prosecutorial fairness and detachment, famously articulated in cases like Whitehorn v. the Queen. The Crown must act with fairness, must not strive for a conviction at all costs, and cannot rely on procedural ambiguities or defense omissions to secure a conviction. They must prove their case fairly on its merits.
And the lawyers in RVMAP, were their names mentioned in the sources?
The sources provided state that the specific lawyers representing the appellant and the respondent in RVMAP are not consistently identified across the material, although some individuals potentially involved might be mentioned in other contexts, but no definitive list for that case from these sources.
Okay. So while MWJ brought significant clarity, are there still ongoing complexities? The law is rarely perfectly settled, is it?
That's very true. MWJ was a major step, a landmark clarification, but it didn't resolve every potential issue at the intersection of trial procedure and fairness.
Like,
well, its interaction with other fundamental principles, such as the accused's right to silence, which means they cannot be compelled to give evidence or assist the prosecution, and the rule in Jones v. Dunkel.
which is a about?
which deals with inferences that might sometimes be drawn from a party's failure to call evidence or witnesses they might reasonably be expected to call if that evidence would support their case. That interaction is still a subject of judicial consideration.
Yeah.
Cases like R.V. Luristis touch on these ongoing complexities. The balance between rigorously testing evidence and respecting the accused's rights remains a dynamic area.
So the conversation continues in the courts. But the core contribution of MWJ v. R seems undeniable, drawing important lines, ensuring Browne v. Dunn doesn't become an unfair trap for the defense.
Absolutely. It was a crucial decision that prevented a venerable rule designed to ensure fairness to witnesses from inadvertently becoming a tool that could undermine the fundamental position of the accused or subtly shift the all-important burden of proof. It strongly reinforced the principle that the prosecution carries the burden, and the defense is entitled to test the Crown's case using legitimate tactical decisions, including decisions about what not to cross-examine on, without being unfairly penalized for it. It's a powerful example of the common law adapting to ensure fairness in the face of complex modern litigation, especially difficult historical cases.
We've really covered some ground today, haven't we? From a somewhat genteel, if bitter, argument over alleged annoyances in 19th century Hampstead.
The veil of health.
Right, all the way to a deeply serious criminal case involving historical allegations in 21st century South Australia. It's quite a journey for one legal principle.
It highlights the enduring nature of fundamental legal principles like fairness, but also their need to be constantly re-examined and refined when applied to new contexts and challenges. MWJ v. R shows a specific principle of courtroom fairness being rigorously tested in the high-stakes environment of a criminal trial involving difficult evidence from the past.
And MWJ v. R's lasting legacy isn't just confirming the rule applies in crime, but clarifying how it applies to the defense. It drew that critical distinction, ensuring the principle of giving a witness a chance to respond doesn't compromise the accused's fundamental rights.
Particularly the right not to assist the prosecution, improving their case and maintaining the burden of proof firmly on the Crown. That's the key.
It's a compelling narrative of the legal system's sometimes dramatic pursuit of fairness. The willingness of the courts, including the highest court, to scrutinize procedural conduct, question assumptions, and ultimately correct potential misapplications of rules to protect fundamental rights. It shows the ongoing process of refining how justice is administered.
Making sure it's not just about reaching a verdict, but doing so through a process that is demonstrably fair to everyone involved, especially the person facing the power of the state.
It's a lengthy and undoubtedly taxing process for the individuals caught up in it, like MWJ, but that journey through the courts, that testing of principles, is essential for the evolution and integrity of the law itself.
Indeed. It ensures that rules designed to prevent ambush, like Browne v. Dunn, don't inadvertently create a different kind of unfairness by unduly restricting the defense or shifting burdens.
Which leaves us with this to consider, perhaps for you, the listener. When you think about the pressures inherent in a trial, the fallibility of memory, especially over decades, the complexity of evidence, and the vital, sometimes difficult role of lawyers in representing their clients, how do we find that perfect point of equilibrium?
The balance point.
The point where we ensure witnesses are treated fairly and given a chance to respond to direct challenges, while simultaneously guaranteeing that an accused person isn't trapped by procedure or unfairly penalized for their lawyer's strategic choices, or yes, even their occasional omissions or errors. Is the balance struck by MWJ v. R and the subsequent refinements the right one for our justice system today?
It raises an important question. How finely tuned can and should that balance be?